Hello and welcome to the next edition of the Jerams Miller Tax Hour podcast. Today I am joined by Sean Randall, independent SDLT expert and someone who's helped us on a lot of cases recently. So I'm absolutely privileged that Sean has come down to our offices to record a podcast for us. And thanks for joining us, Sean.
It's a total pleasure. Thanks for inviting me.
Well, thank you. I thought we'll just jump straight into. Let's talk about some recent cases. I know, obviously, you are now, as I said in the intro, you're an independent SDLT expert, so you are handling lots of interesting. We talked before the podcast, lots of different interesting cases you've got going on. So I thought let's just dive straight into some of the what's coming out there at the moment. What are HMRC particularly interested in, and see where it takes us.
Yeah, sounds cool. So, I mean, look, really over the last, I guess, 4 to 5 years, the tribunals have been busy with stamp duty land tax cases in particular, and there's a reason for that, which is that many people have been exploring, I guess, the boundaries on mixed use matters, multiple dwellings relief. But to some extent, they're also now, I think, beginning to explore the boundaries on restructuring, so much more benign or responsible tax planning, perhaps. Another one I should say is derelict dwellings.
Right.
So these are areas which aren't clear in terms of how the legislation applies to particular facts. It's led to tens of cases, and for the large parts, overwhelming parts, up until the last year or so, the revenue had been winning every single case.
Right. It's interesting because you just said about the mundane restructuring stuff, which is exactly what we do. So, and we've talked quite a lot on recently, especially in terms of some of the restructuring work we've done, because we're corporate tax people, and anytime there's SDLT, you're the first person we call. So, there's plenty going on, isn't there?
There is, and we'll come back to that, I think, which is important. On the restructuring, remind me. But on the thing that seems to have changed really over the last, in particular, 5 or 6 months, has been a trend of the revenue losing cases. And I've written down in a book that they've lost 7, I think, of the last 10 cases or so on SDLT.
That's a big proportion.
Yeah. And I think the main reason for that is, there's a combination of reasons. The first one is that, understandably, these areas are uncertain for both parties. And gradually, as cases get heard, the boundaries become clearer. The revenue have litigated on facts which are relatively weak to begin with, and they come closer to the boundary. And I think in some cases they've reached that boundary and have litigated cases which ultimately now have lost. Another reason perhaps is that, understandably, the revenue are attempted to reapply principles established in earlier cases to different facts. And these kind of areas, the ones I've mentioned, mixed use, derelict dwellings, multiple dwellings relief, these are very nuanced. And it doesn't lend itself, these subjects, to a kind of commoditized approach where the revenue just say the same things each time. And I think they've been caught out on a couple of occasions where actually the fact patterns are different to cases they've won before, and it's wrong just to reapply the same principles.
I think, that's... In a sense, it comes down to the whole tax policy and tax writing, doesn't it? When you're talking about the nuances in certain cases, and I guess for advisors listening and watching, they'll be thinking, okay, so we can read the legislation, we can think we understand the legislation, but actually, if we then still have to apply the facts of the case, that's really where us as advisors earn our money, isn't it? Because you can't expect the man on the street to actually understand all of this and how are HMRC going to interpret this and all of that kind of thing. So, I think, as you say, finding that boundary and having sort of more definitive answers because we've got more case law can only be helpful.
I'm not complaining. So, it's good for everyone really to understand more about the subjects, and it's easier for us as advisors to be able to become clearer on subjects and give more clearer advice, perhaps. But you're right. Look, what we do, the value we add is explaining what we think the right interpretation of the legislation is to particular facts, and applying our judgment to understanding, what the likely approach of the revenue is and the courts to determining something that is uncertain.
Yeah. So some of these cases you're talking about, are they all fairly, are they all sort of first tier tribunal, upper tribunal, or are they gone further?
Yeah, so with a couple of exceptions, they've all been first tier tribunal.
Right.
We're still awaiting a couple of interesting cases, one in particular on derelict dwellings at the upper tribunal. And that's the equivalent, for those who don't know, of the High Court. So that becomes a binding decision unless it can be distinguished. But yeah, mostly it's first tier tribunal cases.
Right. Okay. Okay. Talk to me a bit about derelict property, because I know nothing at all on SDLT. So, sort of, what do we actually mean by derelict property, and in terms of what the SDLT position, what are the nuances in derelict property cases? Okay,
so the starting point is we've got two alternative sets of rates. One applies to transactions in residential property, and another which applies to transactions in anything else. Okay. So anything that isn't residential is by definition non-residential. Non-residential doesn't just mean a commercial building, a shopping centre, or an office, for example. There was a case not heard probably about 5 or 6 years ago now, where a property was bought to be demolished. So it didn't have floorboards, copper pipes, had asbestos, which would inevitably be exposed in the course of any type of renovation. And the company being the purchaser, paid SDLT at the wrong rates. They paid SDLT at the standard rates. Now, the higher rates are the default for purchases of dwellings by companies.
Yes.
So they got it wrong. So the revenue took them to the tribunal, and the tribunal actually said, well, both of you have got it wrong, because the higher rates aren't payable either, because this building wasn't suitable for use as a dwelling. And because it didn't meet that test, then it's by definition non-residential. And so therefore, actually, the company paid too much tax, not too little. And some tax was refunded. Now, off the back of that, reclaim firms have sprung up who have been arguing in social media that if you've bought a property that is derelict, in inverted commas, so it is damp, has mold, water ingress, broken tiles, roofs, window, I don't know, bad electrics and so on, then you might be due a refund.
I have seen some of these sort of emails, things from people like this.
Yeah, now all of those things could be said about the property I bought. So, I mean, they're inevitable in any residential property to some extent. So it's crazy to say that if you bought, in my opinion, if you bought a property with any kind of those general common issues, then it becomes non-residential. However, I don't think it's correct, as the revenue have come close to saying, that in order to pay tax at the non-residential rates, it must be economically unviable to renovate the property. So I think that probably goes too far.
Yeah.
In this case, the one I mentioned before, the property probably was economically unviable. The only economically viable, course of action was to demolish and rebuild. But I don't think that's really the test. So I do think it's closer to that than any type of objective general feature affecting, whether a building could be occupied immediately. But it's a very high bar. So the cases that we've seen, which have been unsuccessful by for the taxpayer, have looked at some properties in a really bad state. And really, you need to distinguish yourself from something that's a pretty common defect, something perhaps that affects the structural integrity of the building, or something that might involve hazardous material like asbestos, which is inevitably exposed during a renovation. You need something pretty peculiar and pretty serious to begin to make a case.
Yeah, because from my very basic understanding, when I actually did SDLT a long, long time ago, and probably actually more studying for exams rather than actually anything in practice, I always kind of took the view that it's non-residential, as in you can't live in it. If you couldn't move in tomorrow, if there was no bathroom and kitchen in there, then maybe that would be okay. But the whole having to whether it's suitable for renovation or not seems almost, as you said, I think you said too far.
A lot of people get confused and say, well, it's suitable for use means you need to live in it. It needs to be suitable to be moved in immediately. That's not the test, okay? So the courts have been very, very clear in saying suitable for use doesn't mean suitable for immediate occupation. So some form of general works are treated as having been done for the purpose of determining whether something is residential or non-residential.
Right.
But I don't think it's right to say you can assume some major things, to address the structural integrity of the building have been done.
That's very interesting and something I've already learned from talking to you. That's why I don't do SDLT.
Yeah, so this one is the one that will be determined at the upper tribunal, a case called Mudan.
Yeah.
Mudan. That's one of those really significantly damaged or derelict properties that was found to be residential.
Yeah.
The taxpayer lost, brought an appeal. It's gone to the upper tribunal. We probably ought to get a decision pretty soon.
Okay. That's good, because some of the cases that sort of I've been interested in from the corporate tax side, I'm now aware they're going to a tribunal, and sometimes these things do take time to get through, isn't it? And people are relying on FTT decisions until then. Yeah,
and that's we'll talk about litigation and the process in a second, but that's an important trend that, certainly I've been involved in cases which were heard in February.
Yeah.
And we're now in September.
Yeah.
And we're still awaiting decisions. So there's quite a lead in time before cases actually do get resolved.
Yeah.
And that's even after the case has been heard. Yep. So there's inevitably a period, maybe a year, before they actually get to the hearing stage itself.
Yeah. So they're not short processes, are they?
No.
Okay, so we've talked a bit about derelict. Let's talk mixed use, because you mentioned about there are people out there who are looking to identify sort of derelict properties and effectively get you SDLT refunds. And I feel like that's, from what I've seen, that's even more commonplace with things like mixed use, and people out there trying to say, oh, we can claim this is mixed use and therefore we can get you a refund. Yeah,
so a bit like derelict dwellings, there's a very large range of facts here.
Yeah.
And the wins recently on mixed use have involved cases which have been very peculiar geographically in terms of geographic factors, whether there's been a river surrounding a particular island on the grounds of the estate, or land, a large tract of woodland which is available to be used by the public and is communal land, not just a right of way, but effectively it's become communal land. So there's some pretty peculiar cases which have been won by the taxpayer recently on mixed use. But the other kind of most common range of facts tends to involve a field or some paddocks which are being used from time to time, usually informally by a farmer for some purpose, whether it's to remove grass for hay or perhaps another type of arable production or possibly grazing. Yeah. And you can see that some facts are very strong in establishing that the land which is being used for those purposes has ceased to be grounds. Yeah. Its function or its purpose no longer is to subsist for the house itself.
Yes.
In some cases, because of the length of that use and the terms of that use and the purpose of that use. In other cases, the use is so passive, informal, infrequent, that actually the land is still grounds. Yeah. It's still available to be used by the occupier.
Right.
So you really, in order for you to win on a mixed use in those kind of contexts, I should have said, you need to show that the relevant land is not grounds. And it's a presumption, understandably, I think, that land which adjoins or surrounds or is near to a dwelling is grounds. You've got to rebut that presumption.
Okay. So because SDLT is paid at the date you do a transaction. So when we're talking, because you actually made me think of a house we were looking at ages ago, me and my wife, actually before my daughter was even born, I think. But we were looking at a house which was going up for auction. And it was so long ago, I was thinking, can we even afford this? But it was a house that actually did have some land attached. I think the extra land was going up for auction separately, but it effectively had a paddock on it. And we thought, how nice would it be to have this house with a reasonable sized garden, but then spend another whatever it was going to be to get that extra land, would that have been judged based on whether it was mixed use at the time, or do we have a period of time that we... Because if you're saying it depends on the use, surely you need to actually know how the buyer is using it before you can actually judge whether it's mixed use.
Well, it's an important point. So you need to classify what you buy when you buy it.
Yeah.
And that test therefore looks at the functional relationship between the land and the house at completion.
Right.
So inevitably that means looking back, how has the land been used, either habitually or recently, not how will it be used. It's not a forward-looking test.
Yeah.
In some cases, how it will be used and how it was used after completion might inform its purpose and function pre-completion. But that's not the test. So you can't buy land and then have an intention to establish a proper function, a proper trade, for example, farming trade or whatever from the land in circumstances where it wasn't used for that purpose before, and then say it's mixed use. Right. A lot of people get confused on that it's a forward-looking test. It really isn't.
So in terms of people trying to do planning for mixed use, you can't... Can you do much, or is it just the people out there trying to make claims that whether or not they can actually factually support them is a different matter? But how do you plan to say, well, we want this to be mixed use, but you can only do that if the seller is willing to just kind of change the use before you buy it? So you can't really do much planning, can you?
It's very difficult. I don't think there's any perfect answer, black and white answer. Inevitably, there are principles of statutory interpretation which mean that if you've contrived to create mixed use, so if you've done something specifically to try to get an SDLT advantage for the buyer, that might be vulnerable to this principle of statutory interpretation in terms of looking at the facts realistically. Yeah. And if that use was contrived, manufactured, had no commercial purpose, maybe it was self-cancelling, maybe, I don't know, it was always destined to end after completion once the advantage, the SDLT saving had been generated. Yeah. Well, those things are super vulnerable. So I'd be very nervous about creating new use in the run-up to completion, specifically to try to get mixed-use treatment for the buyer. I don't think, though, that that's the same as formalising something which perhaps previously was informal and putting some clearer terms and conditions and then saying that the land actually has been used for this purpose, but at completion, there are real rights and obligations for both parties, maybe a tenancy, for example. Yeah, so, I mean, it's quite complex. And as you were talking, I was also thinking, well, actually, this will also have VAT implications as well. So I'm kind of wishing Daphne was on our VAT director was on this podcast as well. But so you've kind of got to be careful. We're talking SDLT today, but that's still going to have ramifications for other taxes like VAT as well. So yeah, no, it's a good point, and it interacts too with principal private residence relief for CGT. If so something that may assist the buyer may shoot the seller in the foot to some extent. It pays to look at all of this in the round. Okay. Have we got any other cases that we kind of want to highlight at the moment with mixed use and derelict land properties? Are clearly a fairly topical one at the moment. Yeah. So multiple dwellings relief. There was a recent case which was won by the taxpayer, possibly the first one in that subject I can think of. That has less relevance now than it used to because of the abolition of that relief, multiple dwellings relief. However, determining whether part of a building or a separate building on the same land as another building is a separate dwelling is still relevant for stamp duty in terms of either the higher rates of SDLT or a particular rule that says if you buy 6 or more dwellings, that's regarded as commercial. Yes. So understanding when something is a single dwelling is still important, but that particular win may be confined to its facts by virtue of the fact that we're now starting to see fewer reclaims on multiple dwellings relief having been made. You've got 1 year. I was going to say, what's that time limit? Because they removed multiple dwellings relief. Was it what was the date? June.
Sometime this summer.
I think it was June.
Yeah. So there is. So that if you're saying they've got until June 25. If there is a genuine claim to be made, then they could make it.
Yeah, that's right.
Okay.
So maybe not so much to talk about on that one. I think the principles in understanding in what circumstances something is a single dwelling are pretty clear.
Yeah.
Which, in my view, is a blend of physical factors and to some extent legal factors. Another case, though, that I think it will become more topical and relevant in particular is the one I mentioned about just general restructuring.
Yeah.
Now, that's a really wide term because obviously there's lots of different types of restructuring. But what I mean by that is something which isn't stamp duty driven, possibly isn't even tax driven.
Yeah.
So something involving possibly a partition, demerger, reconstruction, maybe the acquisition of a company and then some type of post-acquisition restructure, things that we tend to do on a daily basis, in other words. And for many years, there's always been a threat of the revenue applying a general anti-avoidance rule for stamp duty land tax to facts which are benign or responsible tax planning, something which isn't avoidance.
Yeah.
And that's becoming more of an issue over the last, I would say, couple of years. And we've had one case recently, a case called Brindley Place, which was a type of case like that, where there was some post-acquisition restructuring from a corporate, as I recall. And the revenue tried to argue a number of things, including this anti-avoidance rule applied unsuccessfully. So that was a win for the taxpayer. But nevertheless, there are real uncertainties and risks of people falsely assuming that because what they're doing or intend to do isn't driven by stamp duty land tax, they're not doing anything naughty, that this rule won't apply. And that's not the case. It might do. Yeah.
So I think with a lot of, to explain kind of what we do and demergers and things that we've just mentioned briefly, we're normally talking about moving properties. If it involves properties, we're normally talking about that moving intra-group. And so because if you've got a 75% ownership group structure, you can be moving properties intra-group and you have SDLT group relief. So that's often what we rely on. And to us, that's the fairly basic analysis. Where it gets more complex, and I think where it always gets quite technical, is then you come to do a demerger and you're now splitting a group off. So you've relied on group relief at stage one. You're now splitting the group in two. And for SDLT purposes, we have a 3-year period following the original transfer that if we have a degrouping, i.e. the company leaves the group, then we have potential SDLT charges from the original transaction.
Yeah, I was just going to say that it's very difficult to explain to someone that because individual steps are eligible for particular reliefs, whether it's SDLT group relief or stamp duty group relief or stamp duty reconstruction relief. But because each element is subject, meets the conditions for particular relief, that somehow, if you look at all the steps in the round, that it's vulnerable to this particular rule, at least where land is concerned. And so that's a very difficult thing to explain. And I'm very sympathetic because this rule is headed anti-avoidance. So your intuition should be, I've got to be intending to abuse tax legislation in order for this rule to apply. And it's been very clearly established in the cases that there is no precondition of tax avoidance.
Yeah. And that is the big problem. And I haven't actually noted it down. That's something maybe we should talk about. But as we're talking about reconstructions, let's do it. And we've actually headed up this all about SDLT, but the Scots have something different. The Welsh have something else different. They're all quite similar. And in fact, I think how different is LBTT from SDLT, other than the rates themselves in terms of the written legislation?
It's I would say for Scotland and Wales, they've had the benefit of seeing the rules in England work for more than 10 years. And they've learnt some lessons from that. The legislation, I think, is clearer in both cases and it's better structured. But the temptation is to think that because 80, 90% of both regimes in Scotland and in Wales are based on SDLT and overlap with SDLT, that the same rules and the same outcome should apply.
Yeah.
And that's not the case, because that 10% or 20% difference really matters.
That's where
sometimes.
And when we're looking at so in depth and such technical detail, it's that 10 and 20% that really makes the difference between whether there's potential SDLT, LBTT or LTT charges, isn't it? So
for us as tax advisors, whenever we hear that land is in Scotland or Wales, we really should be thinking, my goodness, there's potentially different answers here. Well, the other thing that's interesting is even if the legislation is the same, or substantially the same, we've got 3 different tax authorities.
Yes.
And so we've got the possibility of 2 tax authorities, one in Scotland and one in England, for example, interpreting the same legislation in different ways.
Yeah. And that's the one I wanted to pick up with you, because when we're doing reconstruction, so we move a property within a group first, and then we split those 2 companies apart. For SDLT purposes, we're relying on group relief. But actually, if you read the legislation, it basically says if you're intending to split the group, then you can't claim the relief in the first place. But there is an effective concession by HMRC for SDLT purposes that allow that, on the basis that it's going to be split. And I think it's under Section 75. If 75 stamp duty relief applies, then you can have your group relief. But there's not that concession by Revenue Scotland. So that's what we're always, one of the very first questions, if we're talking about properties and demergers, is where's the property located? Because if it's under LBTT, which is the one that's come up the most for us, we can't move a property into group, get that group relief, because we can't even claim it in the first place. We don't have a degrouping charge issue. We can't even claim the group relief. And that's where the problem is. And Revenue Scotland haven't made that concession. So we're just assuming if this was challenged, Revenue Scotland would have full grounds that we really couldn't argue against that.
I would say in fairness that those tax authorities in Wales and Scotland are sympathetic and very responsive.
Yeah.
And I'm not saying it's inevitable that if you show them that a body of practice in England has been X, that they will automatically follow the same practice. They're alive to the impact of inconsistency.
Yep.
And they've, I think, been pretty fair and responsive so far.
That's really good to know. Is there any kind of process you can go through before, like for us, we have clearance processes. Is there anything kind of process for Revenue Scotland to go through that same type of thing? Yeah,
there are. There's, I think, slightly more generous or kind of processes and quicker ones. I mean, it's a low bar, but they are quicker. Okay. And I guess it's a function of the fact that they have fewer taxes to administer. But I actually look forward to advising on those areas because of the kind of approach taken by those tax authorities.
Yeah. To be honest, I think it might be something that the next time this crops up in practice, whether it's something we could actually write to Revenue Scotland and say, this is HMRC's interpretation on SDLT, this is what we're doing, and if this was located in England, it would be fine. Would you agree with the same kind of practice? Because as you said before, this isn't avoidance. We're doing a completely commercial transaction to separate 2 businesses. And so it does seem a little unfair that, if one's over the border, then that property will end up with a charge. So I think let's look out for the next one that comes up, because there's other ways, and this is SDLT, so I'm not going to go into too much detail on restructuring. But generally, when it comes to LBTT, if we're moving properties around the group, we try and do it via distribution, so that because it's a distribution in specie of the property, you've got no LBTT in this case because there's no consideration. So when we're talking about group relief, it's normally if we've either got debt and there's a mortgage on the property that we have to rely on it, or we don't have the reserves to do it via distribution in specie. So luckily, I think most of the ones so far we have actually done via distribution and got around the problem that way.
Yeah.
But I actually want one to come up now so we can actually test the theory with Revenue Scotland and see what happens. And I wonder if anyone else out there has done that, let us know, because that would be a really interesting one to come out of this. If there's one thing that comes out of this podcast, I want the answer to that question.
Good.
Any more cases, or should we talk about inquiry process and things?
I think let's go to inquiries.
Yeah.
And I guess on that, I just wanted to talk about the process. Certainly so far as SDLT is concerned, I mean, there are different processes in Wales and Scotland
Right.
and for shares. But so for SDLT, the general rule is that there's a 9-month window. And that window starts 14 days after the completion date in most cases, during which time the revenue can serve something called an inquiry notice, which is a notice saying that they intend to check the self-assessment in the stamp duty land tax return. Now, those inquiries tend to be opened, in my experience, right up to the 9-month window.
Right, okay.
So the risk of an inquiry doesn't diminish over time. It exponentially increases. In the last couple of weeks of that 9-month period, there's every likelihood that there could be a check.
I was going to say, that doesn't sound uncommon compared to some of the inquiries that I see coming through. And sort of, if it's a self-assessment inquiry and 31st of January, all the inquiries and notices are coming in January kind of thing. So it's quite common, isn't it?
And it's perfectly obviously reasonable for the revenue to check at a self-assessment.
Yeah.
I'm not saying that receiving an inquiry is an indication that you've done anything wrong, and the revenue will certainly find against you. But you have to follow the process.
Yeah.
Now, the other thing is that for England and Northern Ireland, not so in Scotland, there's no defined time period within which the inquiry must be closed.
Yeah.
So, they could theoretically take more than a year, and the only remedy available to the taxpayer is to seek a direction that the revenue from the tribunal, that the revenue close the inquiry within a particular period. And obviously, if they're being slow in responding to, information that you've provided, then obviously you can nudge them a bit, but really it's at their discretion.
Yeah. So when we're talking about inquiries, for most inquiries I deal with on sort of the corporate and personal side, there's not normally any tax payable until the inquiry's decided. Is that the same with SDLT, or is there sort of an upfront, this is what they say and you've got to pay it and then you'll get a refund if they turn out to be wrong? Because I think that in some VAT issues, that can be the case. Yeah,
there's something called an accelerated payment notice, and we're not going anywhere near that because that's that's specifically confined to anti-avoidance or avoidance cases. So here we're just talking about, let's say, any type of general transaction, nothing close to the boundary of tax avoidance. Inquiry notice is issued. Usually appended to that inquiry notice is a list of generic questions. Understandably, because the revenue don't know very much. And this is another point really I'd like to make, which is it's very common in the SDLT return to not be able to explain your transaction. There's all sorts of different SDLT transactions and involving partnerships or leases or, subsales and things. And it's difficult to explain.
I was going to say, property transactions can get very complex.
Yeah, and it's difficult to explain exactly the reason for self-assessing in the way that you have. And that means that the revenue are likely to give you a long list of questions to try to draw out exactly what's happened. The alternative is that you're proactive and choose voluntarily to give an explanation to the revenue, which is a very common thing to do.
Right, okay. Does it normally help to be more proactive, or does that just make them think, oh, we need to look at this a bit more because they've said so much in their white space note or whatever?
Really depends on the context. So I think in many cases it's good to show that the revenue that you're being transparent, you've taken advice. That sounds self-serving. It's good for a taxpayer to show they've taken advice. That the advice is based on all the relevant things, establishing cases, applied to the facts reasonably. It may not say that the position is certain from the taxpayer's perspective, but it should show the revenue that this is a robust position, it's a responsible position. And it may well dissuade the revenue from opening an inquiry.
Yeah.
So I'm a big fan of using covering letters. I don't believe in hiding from the revenue and just trying to game the system by, getting away with it. In any case, if you don't use a letter, the revenue still have the balance of 4 years.
I was going to say, is it the same that you've actually got a much longer period if they effectively discover something that they couldn't, or normally if they should have known it, then they've got their normal time period. If you haven't told them something and all of a sudden something comes to light to them, which actually makes me think of another question I was going to ask you. Where do they get their information from? Because you said they normally do, and I've only ever been in one inquiry involving SDLT, but there's normally a whole host of questions for them to do some information gathering. But other than the self-assessment return, I assume they've got the land registry and they've got plenty of information from there. Is there anywhere else that they get any information, or is that kind of the extent?
It's difficult to speculate. So they've got this Connect system, which draws together information from lots of different sources. It's not obvious where they might find information which leads them to the conclusion that there might be an underpayment of SDLT. It might be an inquiry in a different tax, for example. But the land registry are pretty good, I think, in asking for more information about a transaction in circumstances where there's no SDLT return. Not all land transactions are notifiable. So in some cases, it's quite right that there isn't an SDLT certificate. But in some cases, there should be one. There isn't. And the land registry are pretty good in stopping the registration application from being processed until they're comfortable that the SDLT treatment has been fully self-assessed.
Oh, right, okay. Yeah, because there's, one example where, please don't correct me if I'm wrong, because I'm hoping I'm not. One example where we commonly come across, coming back to demergers, if we are doing distributions in specie, like I explained, there's no consideration and therefore there's no SDLT return. So that is one example where, God, I was right there. But so there are cases where you might not have those returns. But I do have solicitors kind of saying, some solicitors, not everyone, but it's not uncommon where a solicitor said, we're just going to put an SDLT return on with a £1 consideration to show that there is a paper trail. And I find that a bit strange.
Yeah, well, this goes back to what I was saying before, that sometimes it's difficult to explain a transaction. And you may want to kind of, it sounds awful, but fudge the system by voluntarily explaining something that isn't actually notifiable to get a certificate to enable the registration application from happening. So this concept of using nil returns to ensure that something is registered it's quite legitimate, but it's a little bit of a fudge, really, because if you don't need to file a return, it's going to cause some confusion if you file one.
That's the problem, isn't it? So, when I first came across that years ago, I kind of thought it seemed a bit strange, but it wasn't just one solicitor that's done it. So, I guess if it makes people happy and it gives them a paper trail, then as long as there's no downsides to it, then. As long as no one's asking me to do it for when I'm not an SDLT person. Okay, so if we have an inquiry, they can take quite a long time. But if there's no payment up front or anything, is there any incentive? Because you said that we can go to tribunal to effectively push them along. But is there any incentive for the taxpayer to do that if actually the tribunal pushed them along, HMRC come to a decision which actually means you've got to pay more SDLT? Why don't you just let sleeping dogs lie until they come to something?
Well, you're right. So the risk is uncertainty, and you may commercially want to resolve the position one way or the other sooner rather than later. The other point is interest. So interest will carry on accruing at the general HMRC rate for late payment of tax, which is 2.5% above base rate. So that's 7.5, I think now.
Yeah, I think it's going up. It was nowhere near what it was before, which was sort of a few percent, wasn't it? Before,
So you may want to stop interest from carrying on accruing indefinitely whilst the revenue respond. There is a concept of paying on account. And I think there was an old concept called tax credits, maybe before your time, Nick.
maybe.
You look very young.
Yeah.
God, that's scary. So it's a bit like a voucher, like a
Right.
gift voucher or store voucher. So you could buy credit against tax generally and use that to offset any tax that's payable.
Yeah.
I don't think it exists anymore. But however, you can make an arrangement where you pay the tax on account. It's accepted by the revenue to be on account. And if tax is found not to be payable, well, then you can get it back with interest.
Right. Okay. Interesting. So we've got an inquiry opened. HMRC come to a decision which we don't like. Where do we go next? Are we just going straight to the first tier tribunal to appeal it?
You can do. So first thing is that you need to be mindful of the time limits in bringing an appeal. But bringing an appeal doesn't automatically start the litigation process, which culminates in the tribunal hearing.
Right.
So you can what's called request a review, which is a second opinion within the revenue. So the matter will go to someone who is legally trained, usually in the solicitor's office, who may be an internal barrister or solicitor, who will look at the facts afresh to determine whether the original decision was correct.
Yeah.
And this kind of review, it's understandable to be sceptical that the revenue have, if there's any kind of likelihood that the revenue would contradict themselves. But actually, I found over the last 6 months or so for the revenue to overturn decisions at review stage. I've got 3 examples.
Yeah.
And it's if you don't make any new arguments and don't show any new facts, then it's almost impossible, I think, realistically, to expect the revenue to overturn a decision.
Yeah.
However, what you can do is present new facts, make new arguments, expose flaws in the reasoning given by the original officer. And I think if you do that and present the new reviewing officer with a technical reason for overturning the original decision, now you've got a chance.
Okay. So where do you normally come in? Because obviously you're completely independent. So do you normally come in at the start of an inquiry process, or do you find that actually the accountants tried to have a go themselves and then they realise actually we're losing this case, so let's bring Sean in to kind of help us with the review stage? Or
a bit of both. Right. That's a good moment, really. So when the revenue have closed an inquiry, they've reached a decision. It's not maybe it's a surprising decision or a disappointing one.
Yeah,
that's a good time for there to be a second opinion, within the acting for the taxpayer to look at everything afresh in the round, work out actually whether this is something to capitulate immediately, prevent any more interest from being payable. It's unsustainable or unrealistic to expect an appeal to work, or actually, on the contrary, to make new arguments, pull new facts, re-present this in a different way. To try to explain.
Sometimes it's just the way you present something, isn't it? We have the same kind of thing with reconstructions, because if HMRC refuse under 138 or 139 clearances, you can ask for the correspondence to be submitted to tribunal for their review. And that's sometimes when people come into us and say, we've done this, we've been refused. Can you help us draft something to kind of persuade the tribunal, which is the same kind of process, except we're now talking internal HMRC review.
Yeah, and again, it's super understandable that once there's a decision, you think that's the decision of the revenue.
Yeah.
And to some extent it is, but actually it's the decision of one person in the revenue.
Yeah.
They might have made some inquiries within the revenue. They might have sought advice from someone, whether it's in policy or possibly from the technical team in the solicitor's office, but not necessarily. So in some cases, it is realistic to expect officers to make mistakes, and for someone afresh to say, well, this isn't going to be worth our investment in terms of taking the matter to the tribunal because we're likely to lose. They've got a litigation and settlement strategy where if the case has, on balance, a more than 50% chance of success in the opinion of the revenue, then they ought to take the case to the tribunal. Right. So what you're trying to do at review stage is show the reviewing officer that actually the likelihood of success for them is under 50%.
Right, so that's the real target. It's not like this is an absolute slam dunk. It's if we can convince them that there's less than 50% chance, then they should try and drop it. Okay, that's interesting. stick to that 50% rule then. No, because I was actually going to say that's exactly what we've come across in other taxes where we have asked for a review, because we've thought, well, actually, it's now that we know that the review is going to effectively the solicitor's office, as you mentioned, the same with SDLT, they're looking at it from a different perspective in a sense. They're looking at it from, can they litigate against this or not, rather than just this is what the view is of the inspector who's been dealing with it for the last year or two. So it's kind of, it is, I agree with you, it's a completely different, well, not necessarily completely different, but it's a different kind of view that they're taking as to sort of the commerciality, I think, more of the case as well, isn't it? So, yeah, it's interesting, the inquiry process, because I've only ever been involved in one, which was about the 15% rate on corporates acquiring, and they were basically questioning whether there was any private use over the next 2 years, kind of thing. And in reality, what was happening, it was a holiday home that was bought by a corporate, and so the 15% rate was in question. And they'd actually had gone down and stayed there, but they'd gone down and stayed there so that they were staying there during renovations, so they were managing renovations. And I think HMRC backed down on that one, because we kind of said, well, they're not staying there for private use. They're staying there as part of the renovation process, which isn't kind of, they're not staying there for their pleasure, kind of thing.
Yeah, I mean, that's a good argument to make. It's been aired before unsuccessfully by the taxpayer. So
got lucky on that one.
well, to some extent, but I don't know the facts. But it's an argument I would make, and I'd be pretty optimistic about it being successful. If you can establish that the people occupying were occupying in their capacity as directors of the company, and the purpose was solely in connection with the trade of the company. But you're right. As soon as there's a blurred boundary between that purpose and actually getting some incidental pleasure or benefit from staying in the place from a particular period of time, then now you're starting to really, tread a very difficult line in terms of winning, I think. Yeah.
And I think, again, that's what we've already mentioned it, but that's where it comes down to kind of us as advisors, whether we can take an opinion, because in that case, they'd acquired the property in a company on advice from another accountant. So if you're going to acquire a property in a company on advice from the accountant needs to also say, okay, well, it's not just that sort of the income isn't going to be subject to personal tax. You talk about corporate rates, and if you don't need the income, then do it in a company. We also need to consider the other things like SDLT, which I think sometimes are sort of secondary to sort of the main sort of ongoing personal tax issues and CGT issues and that kind of thing. So, it's kind of making sure that the full advice is obtained before you do the transaction. Anyway.
Yeah, no, and in this particular subject, the 15% rate is a really dangerous area. So I acted for someone who was relatively elderly. They wanted to move their family home now that the children had left home.
Yeah.
And he was by himself. He wanted to move the family home into a company and develop the property into a house of multiple occupation, for which he had a license and permission.
Yeah.
So he transferred it to a company, and obviously the purpose of the company's acquisition qualified for relief from the 15% rate and also the annual tax on envelope dwellings. So far, so good. But the renovation actually took quite a while, about 6 months. And for security and to project manage the renovation, he stayed in a building on the grounds. It was some type of annex. And it actually didn't have permission to be used as a dwelling. And physically, it probably wasn't good enough to be a dwelling.
Yeah.
But the revenue picked up on the fact that he was staying at the property for a long period of time in connection with the renovation.
Yeah.
And we had to argue, and we did so successfully in the end, but it took a long time. We had to show the revenue that the building that he was staying in wasn't itself a dwelling, didn't have permission legally, physically it wasn't suitable to be used as a dwelling full time. And in fact, he did stay from time to time at his children's addresses, which were nearby. So it was a pretty temporary affair. It was meant to be temporary. but the reason why we won is because it wasn't a dwelling of itself. And although it was a building on the grounds of the dwelling, that meant it still wasn't enough under the legislation to say that the 15% rate applied.
Yeah.
So I think on a technicality only, that person was successful.
Yeah.
And as soon as you have any type of personal occupation of a property which is owned by a company that you're connected with, well, then on the face of it, there's a problem.
That's where it starts to become an issue, isn't it? So in your case, how did HMRC even know that he was staying on a dwelling that wasn't a dwelling, but was still staying on that, it's living there as if it was a dwelling?
So the returns will always say that the purchaser is a company.
Yeah.
So it will state limited under the name of the name of the purchaser. If the description of the transaction is residential and the buyer is a buyer is a company rather, then the revenue ought to put the two together to say this might be a 15% rate issue. And
so that's when they open the inquiry and ask all their questions.
Just to ask questions. And they're not saying anything is wrong, but they will ask, how has the property been used? To what extent, if any? Has anyone connected with the company been occupying or staying in the property? And then suddenly information is given which the taxpayer didn't know was sensitive. In many cases, they weren't advised about the 15% rate or AZ at all.
Yeah. Interesting. Okay, so I'm a bit conscious of time, actually. So I did want to talk very briefly about incorporation because it's something, again, rather selfishly, I want to talk to you about it because it's something we deal with. So a lot of the time we get questions coming from clients where they will say, we've got a property portfolio, we want to incorporate it for, the finance cost issues and things like that. And so what's the tax implications? And the obvious ones are you've probably got CGT and you've probably got SDLT unless you can claim relief. And so I kind of, when I'm first introduced to a client, I'll talk about sort of, you've got three basic things you can do. You can incorporate and pay the tax. You can move to an LLP and then to a limited company, but it's really dodgy and please don't do it. And I'm not going to advise you on it if you want to do that. And then you are already a genuine partnership and you can incorporate anyway. So let's start with the genuine partnership thing because that's kind of the main work we actually engage to do because we basically look at something if it's jointly held, whether or not it's legally a partnership, look at what the Partnership Act says, which is under Section 2 of the Partnership Act, if you're operating jointly with a view to profit effectively. And if you can prove that, and there are cases out there sort of, I know there's Elizabeth Ramsey, which is, I think HMRC's guidance has moved on a little bit, but sort of that 25 hour a week is still a fairly good rule of thumb. And so for CGT purposes, we're saying, well, if you are a business and you're incorporating in exchange for shares, you can have incorporation relief. And the SDLT argument on that is sum of lower proportions. So do you want to briefly explain what sum of lower proportions actually is? I never call it a relief because I don't think it is technically a relief. It's just how you do the calculation to get to what the SDLT.
You're absolutely right, but I mean, effectively, it is.
It is effectively a relief. Yeah.
So the point is that moving a property from a partnership to a company that is controlled by the partners of the partnership falls within special computational charging rules.
Yeah.
So those special rules override the usual way stamp duty land tax is calculated. So now we don't care about, oddly, whatever is given for the property. It could be cash, could be shares, it could be assumption of debt, it could be a number of things.
Right.
I don't care about any of that. So whether and to what extent any consideration is given in the real world, irrelevant.
Yep.
That's the good news.
Yep.
Bad news is, or maybe not so bad, but these special rules apply which deem there to be consideration. So you have to use these rules to work out in the SDLT world what consideration was given.
Yeah.
Now, they're very formulaic, very prescriptive, narrowly defined rules. But in essence, as I said before, if the company that buys the property is connected for tax purposes with individuals who are the partners in the partnership, well, then you ought to get an effective relief under those special charging rules.
Yeah, which is the sum of low proportions.
Which is the sum of low proportions.
So that's kind of where we say that is genuine planning. You already have a business. You're already spending a lot of time. So this doesn't work for people who, this is just a bit of a side hustle and they have an estate agent doing all their managing, because that's not enough activity to justify a business, at least for CGT purposes, and I think therefore as well for SDLT.
Yeah. So we're talking about general partnerships which are unregistered, for the most part, I think.
Yep.
And it's an area of law in what circumstances a valid partnership exists or not. And it's actually quite nuanced, and I get nervous about being definitive on that area because it's not a tax question.
It's not a tax question, as you say. It's a matter of law. It's the Partnership Act. But it's also, as with a lot of things we keep talking about, there's often not a definitive yes or no. You're looking on balance. Would we say, and do we think we could make a successful argument to HMRC to say this is a genuine partnership? And that's kind of, as you say, there is a little nervousness about it because, as you say, it's a legal question. Yeah, as much as it is a tax one, really.
Yeah, and it's sometimes misleading to think that because of the activity and the what the intention was on the parties, that it definitely is a partnership.
Yeah,
it's something to look at afresh with cold eyes and really get to the bottom of. No matter what the client says or how passionately they believe there is a partnership, there may well be one. But actually, if there isn't one, you don't get this effective relief at all. It's black and white. Everything turns on the existence of a partnership.
To be honest, that's kind of with these projects where we do it. Actually, a lot of our work is before we can even engage, because otherwise we'll be engaging, charging them thousands of pounds to just say no. So we kind of want to have a reasonable certainty that we can put an argument together for them before we can even engage. So we do have a lot of upfront conversations and those things to actually get the facts to be able to come to some sort of conclusion. So that's kind of the planning, which I think is perfectly acceptable. It is genuinely commercial purposes, and HMRC shouldn't have a problem as long as they agree with our analysis of whether there's a business and a genuine partnership. The one, as I said, when I was kind of introducing this topic, the one I don't even bother talking to clients about, or at least I immediately try and debunk, is this idea that you can move into an LLP. And again, coming back to our reliefs that we've mentioned, the sum of low proportions and the incorporation relief for CGT, the idea is you move into an LLP, so you're in partnership, which is tax transparent, but you've now got a legal partnership, and you then move into a limited company. And because you've got a legal partnership, we can still rely on our incorporation relief and some of low proportions. The problem is that we have anti-avoidance rules to say why you are moving from LLP to limited. HMRC can look at the whole thing in the round and say, no, really your whole purpose here. So you have to be able to genuinely show why did you move LLP and then why did you move limited. And I think there's a lot of miscommunication, let's call it, that as long as you wait 3 years in between the two, so move LLP, wait 3 years, move limited, you'll be fine. But I don't think that holds true in the real world. I think the anti-avoidance rule just says whatever period of time between the two, it can be caught, and it's just 3 years is kind of outside of HMRC's radar a little bit, that's all.
Yeah, agree with all of that. So the test is whether the second transfer was involved in connection with the first, and those words involved in connection with are subject to debate to some extent. But if there was always an initial plan to incorporate, and the purpose of moving into the LLP or a partnership was to benefit from the special charging rules on getting it out of the partnership to the company, well then you're definitely on the back foot at best. And unless you can establish a genuine reason for moving it into the partnership in the first place, and absolutely no plan to incorporate later, well then you're definitely going to be, as I say, finding it difficult to prove a negative, no? And proving a negative evidentially is much harder. Yeah. So you're having to prove that the second transfer wasn't involved in connection with the first. And the revenue can use their hindsight to say, well, if one has happened after the other, that actually it might have been a part of a plan to incorporate, even if the gap of time between the two transfers is 3 years, which by itself has absolutely no relevance at all. So anyone who says, magic 3 years is talking absolute rubbish.
Yeah. And I think that's and we were talking about this before as well, kind of because they might have been successful in incorporating other businesses, or not even necessarily, they might not even technically be businesses, but other portfolios in that way, and it just didn't happen to be caught by HMRC, doesn't mean that that will apply to the next client that comes along, and HMRC might well pick that one and spot it, and SDLT will be an issue. So
it's tax planning based on not paying tax, which is crazy. It's something that we wouldn't advise.
Yeah, I think we're pretty much running out of time. So I thought we didn't even get into the likes of what Property 118, unless that's for landlords are doing. So we'll leave that one alone, and we'll just spend a couple more minutes talking about budget projections as we're a month away now. That's coming up very quickly. It's quite scary, actually, but probably the most hotly anticipated budget of my career so far, at the very least. So any special things coming out of on SDLT?
It's an odd one, this one, because usually, very selfishly, stamp duty occupies a lot of the headlines and the speculation. But this time it's all about CGT and non-DOMs and business assets.
Disposal relief,
bad relief. Thank you, entrepreneurs relief.
Yeah.
So actually, the pressure's off stamp taxes practitioners to some extent. I think it's inevitable that there will be some changes in stamp duty.
Yeah.
It's just the political imperative in being seen to be helping first-time buyers or another class of person is too much. So we absolutely know, according to the Labour manifesto, that they're inclined to increase the surcharge for non-residents by 1% from 2% to 3%. Mm-hmm. I could easily see that the other surcharge for individuals buying an additional dwelling who aren't replacing their main residence from 3%, that might well go up. Yeah. And believe it or not, in the scheme of things, overall, around the world, that additional dwelling surcharge and the non-resident surcharge are quite light.
Okay.
So even in combination, that at 5%, they probably could go up a little bit without a huge effect, I think. But so rates to go up. One thing that we don't know is whether the Labour government will reverse the intended reduction at the nil rate band, which is 250k.
Yeah.
So that's due to go down to 125. It's been ages since it was 125 due to all the holidays and things, stamp duty holidays. But it's earmarked to go down. It's set to go down from April next year, from 250 back down to 125. The Conservative Party had promised to make that increase from 125 to 250 permanent. Yep. Question whether the Labour Party will also do that. If they don't, well, then they probably need to do something to be seen to be helping first-time buyers even more. Yeah,
I think that's interesting, because with SDLT, I think it's less of a revenue raise as some of the other taxes, isn't it? Well, certainly is less than some of the really big taxes, but there's some that they pledged not to, like things like income tax relief. They've pledged not to income tax relief. They've pledged not to increase rates of income tax, although they haven't necessarily said specifically about touching reliefs. But whereas SDLT, I think it's more about things, as you say, like the first-time buyers. So it's more political than it is necessarily specifically of raising revenue for them, I think.
Yeah, I agree. I agree with that. So economically, sometimes some of the measures are counterproductive. Yeah. But politically, they're quite interesting for them. Yeah. It together raises 14 billion stamp duty land tax. So it's not a tax that they can just ignore or eradicate without something pretty significant to replace it. So I am expecting changes, particularly on rates. Watch the 250 nil rate band, see what happens with that. Apart from that, who knows? Literally anything could happen.
Yeah, it's interesting. That's exactly why I think so many people are talking so much more than I think I've had more conversations than ever before, I think, in anticipation of a budget. So that's been fascinating. And because I don't deal with SDLT, it's all of these things are always interesting, especially for a tax nerd like me. So thank you so much for joining me. And everyone out there, hope you found that useful, interesting. If you like the podcast, feel free to like and subscribe, do all of that stuff. And hopefully we'll see you on the next one. Thank you.
Thanks, Nick.
Cheers.